Okay, we will, oops, I need the, hello? No, right. Okay, we are going to resume item 11. We've had the staff presentation, and I believe there are no questions of staff from the board members, so I'll move straight to the speaker cards. I have 4 speaker cards. The first is Nathan Jacobson.
Good afternoon, Vice Chair Spivey Weber and board members. Nathan Jacobson for the Division of Water Rights Prosecution Team. The prosecution team fully supports the board's draft order revoking license 5763, which authorized diversions for the long since closed Masonite plant on the Russian River. As noted in the draft order, there was no credible evidence showing beneficial use by Masonite or Millview since the plant was closed in 2001. The last report showing any water use that was submitted to the division was in 1999. So Millview has made a couple of policy points in its comment letter submitted on this item, and none are really relevant to the issue of non-use under the license. And despite their assertions that they made attempts to preserve the right, again, there was no credible evidence presented at the hearing to show that Masonite or Millview took any significant actions to preserve that right. So water hasn't been used for approximately 15 years under license 5763, and the prosecution team supports the board's adoption of the draft order. Thank you.
Thank you. The next speaker is Christopher Neely. Or Neely, I'm sorry.
Neary.
Neary. Well, it's
I'm
light.
sorry for
It's
my-
very light.
Yes, I use a pencil. Good afternoon, members of the board. I represent Millview County Water District, and I'm here to answer any questions you might have. We filed a brief and we filed a comment. I just would illustrate that the record frames abundant reason why this board could, in the exercise of its discretion, order the retention of at least 1,303 acre feet of this 4,200 acre foot license. The record really does not point to any policy reasons why the board should adopt a strict application of forfeiture in this proceeding. And it's not necessarily framed as an either-or issue, because the license is for 4,200 acre feet. The last reported use by Masonite was 1,303 acre feet at the end of 2001. Millview acquired the license in 2006, before the 5 years had expired. We attempted to initiate secret proceedings that would allow us to purchase the right, and that required the cooperation of the division staff, and there was testimony that the division staff didn't have the resources in that 2008 to 2014 time period to cooperate with Millview in the environmental process. So in the middle of this forfeiture period, which goes back from 2009 to 2002, Millview acquired this right, a municipal purveyor in the county where the water originates. And so we think this is a policy issue addressed to your discretion. You have the discretion to revoke the entire license, and you also have the discretion not to revoke the entire license. In this case, where Millview was operating under a disability, partially contributed to by the disability of the division staff to process our change petitions. I think it's our request that you exercise your discretion in a reasonable and benevolent manner to retain the 1,303 acre feet in Mendocino County where the Russian River is fully appropriated. So I'd be happy to answer any questions.
Any questions? Thank you. The next speaker is Andrew Nicole.
Thank you for the chance to speak on this matter. My name is Andrew Nickel. I'm a resident of Mendocino County, and I'm a property owner in the Millview Water District. I'm here to make a passionate plea to you folks to preserve this water license. I do feel that Millview has made a very strong effort to transfer, purchase this water right and keep it active. When the Masonite plant was abandoned and disassembled in 2002, Millview immediately began efforts to purchase the right, and in fact did purchase it, then began efforts to transfer it. The water license was transferred to Millview in 2007. Shortly thereafter, the board started revocation hearings regarding this license. Millview requested a hearing. That hearing was requested in 2008. The hearing didn't take place until 2014, 6 years later. To me, it doesn't seem appropriate that during the process of Millview's efforts to transfer this right, that a period of non-use occurs, partly because of the board's delays in transferring the license, to a point at which you can say the license was not used and should be forfeited due to non-use. They made every effort in the world to transfer this license during this period of time. One thing that I didn't hear mentioned was that Millview is and has been under a new hookup moratorium for 13 years. This has had a severe effect on people in our county and in our area. Businesses can't expand, property owners can't develop their property, people that have bought lots and want to build a single family residence can't even do it. They can't put a mother-in-law's quarters in the backyard. It's completely put a stop to Millview's adding of new customers and any growth in this area. And it's just to not focus and put some attention on this moratorium and the effect it's had on the people in this area, it doesn't seem appropriate to me. I've always felt that, you know, in a board like this, one of its roles would be to protect the less politically powerful, which Mendocino County is with regard to Sonoma County Water Agency. And I think that Sonoma County Water Agency looks out for their own interest, and it's up to the board to weigh in between Mendocino County and Sonoma County and decide where these water rights should go. I've read what Sonoma County Water Agency submitted as reasons for their recommending that you revoke this license, and both of their reasons start with the word could. It could reduce, force us to reduce flows. It could force us to change this. There is no fact cited. There is no science cited. It's just a very casual statement that this could affect our ability to continue certain flows in the river. And I think that, you know, before you're going to take this water license from Millview Water District and reallocate it to other people, that you should have some facts to back up Sonoma County Water Agency's claims. I think if you look at the map that's part of your staff's report, you can see that the Millview Water District pretty much surrounds the old Masonite site. The Masonite site is somewhere near 200 acres. It's vacant right now, and as this property becomes redeveloped Millview is going to be the logical water district to provide water to this area. As well, the Mendocino County has just completed the Ukiah Valley Area Plan, which plans much of the future growth in the Ukiah Valley in the Millview Water District area. This water license is critical. It will help Millview get out of their moratorium, and it will also help the county provide affordable housing and additional opportunities in Mendocino County, which we need very much. I request that you guys put some real hard thought into this and consider the fact that Millview is not a for-profit organization. They're a county water district simply trying to provide water hookups for the demand and the people in their community, and use your discretion to allow at least a portion of this license to be transferred to Millview so that they can continue to provide the wonderful services that Millview has provided to the people that live in their district. Thank you.
Thank you. Alan Lilly.
Good afternoon, members of the board. I'm Alan Lilly, and I represent the Sonoma County Water Agency. Just by way of background, Chair Marcus is not here. She was the hearing officer for the water right hearing that took place that's now being discussed in the draft order. And Sonoma County Water Agency participated in that hearing. It was in April of 2013, just over a year ago. And at that time asked the state board to issue the an order revoking the license. Sonoma County Water Agency is interested in this proceeding because it has almost all of the water rights for storage in Lake Mendocino, and it must maintain minimum stream flows in the Russian River all the way from Lake Mendocino down to the Pacific Ocean, which is about 100 miles. And it has to maintain those regardless of what diversions are made by others along the way, and there are hundreds of diversions. So any additional diversion or any reinstatement of a diversion of water from the Russian River means that Sonoma has to basically make up for that water with additional releases of water from Lake Mendocino to replace the diverted water so that the downstream, in-stream flow requirements still are met. And of course, we have to meet those. And with the reductions in the imports from the Potter Valley project that you've heard about in recent years, because now more water has to continue down the Eel River where that project is located, the water supply situation has become much more severe. And in fact, there are very clear facts about this. The Sonoma County Water Agency has had to come to this board with temporary urgency change petitions to ask for temporary reductions in the in-stream flow requirements, basically just to preserve what little water is left in Lake Mendocino. And we filed those in 2004, 2007, 2009, 2013, and I would say 2014, but it was so dry this year we actually filed it in December of 2013, and it is in effect in 2014. So it's real, and every additional acre foot of water is a reduction in that lake's water supply, and that lake is used for the flows for both water supply purposes and equally important for the fishery and in-stream flow purposes. So because of these risks, and which would be increased if diversions could start again under this water right license, and because of the long history of non-use under this water right license, the Sonoma County Water Agency requests that the state board adopt this adopt the draft order. Millview has raised some arguments in its letters and in Mr. Neary's comments, and I'll just respond very briefly to those. One is they say that Masonite had a pre-1949 priority, which should be given some kind of priority over Sonoma County Water Agency's water right, which has a 1949 priority. That could be the case if Masonite had actually been diverting and using water before 1949, but there's no evidence in the record that that happened, and actually they filed their application that led to this license in 1954. And in fact, there's a contact report that Redwood Valley County Water District submitted in comments on this draft order, which says that the state board staff concludes there's no evidence of that pre-1949 use. And actually this board, or it's actually its predecessor, the State Water Rights Board in 1961, considered this issue. And actually at that time, Masonite asked for a request that its license have a priority higher than Sonoma's priority. And the State Water Rights Board rejected that argument. So this isn't the first time this issue has come before this board, and there's no reason for the board to reconsider that now. And finally, any pre-1949 right is for continuous use since before 1949. And that's, of course, the whole point here. We don't have continuous use. We have non-use for at least a decade and perhaps even more. The water supply arguments certainly are important and need to be considered, but the bottom line is Millview does have an alternate source of water here that it can get to its customers, and that is a contract with the Mendocino County Russian River Flood Control and Water Conservation Improvement District. And actually, the State Water Rights Board noted that in 1961 when it adopted D 1030 as well. And I'll just read one sentence, which comes from pages 39 to 40 of that order. It says, the controversy, that is whether or not Masonite should have priority, then it was Masonite, should have priority over Sonoma, does not concern the availability of unappropriated water, but whether Masonite Corporation should be required to pay the Mendocino District for that portion of the water which it diverts and which will be subject to appropriation under the prior state assigned application. So that's the end of the quote. So the Mendocino District, through D 1030 and subsequent actions, obtained its permit. It has a permit for 8,000 acre feet per year of water, the project water that it can divert from the river, and it contracts with entities and is available to contract with Millview for a water supply. So like a lot of water right disputes, it's emotional on the first level, but in the bottom line it comes down to money, and that's what it is here. It's whether or not Millview has to pay the Mendocino District for the water supply. The hookup moratorium, Millview did put a Department of Public Health order into evidence during the hearing, and that order talked about limitations in physical facilities, not in water rights. So it's not entirely clear that that moratorium is based on water rights. It appears to be based on facility limitations. But in any event, we encourage the State Board to follow its water right process as it has since 1961 and as the draft order would here. Finally, on the question of diligence, it's what Millview said just really isn't correct. They try to blame the Division of Water Rights for the lack of diligence, but Millview is a public agency, and under CEQA, the California Environmental Quality Act, they are fully qualified, and in fact, under the guidelines, would be the CEQA lead agency. So they had the ability and the authority to issue their own notice of preparation, prepare and circulate their own draft environmental impact report, and to certify their own final environmental impact report. They didn't, of course, the Division of Water Rights and the State Board would have been a responsible agency and could have commented during that process, and undoubtedly would have, but Millview did not need to wait for the division to take any actions regarding CEQA. So it's really not fair of them to blame the division for whatever delays have happened. They made a decision not to do the CEQA work, and that was their decision, but it was their decision. They shouldn't blame anyone else for that. So for these reasons, on behalf of the Sonoma County Water Agency, we request that the State Board adopt the draft order.
Any questions? Thank you. Any final comments from the staff? I do want to point out that I was one of the members of the hearing team, and so I was definitely there for the entire process. Then I will go ahead and move adoption. There are no change sheets, are there? Oh, that's right. That we did. We took the one request from Sonoma. That's right. So I move adoption with the change sheet.
I will second the motion.
All in favor?
Aye.
Aye. Thank you, and thank you. So, Mr. Howard, do you want to introduce item number 12?
Of a proposed resolution regarding drought-related emergency regulations for curtailment due to insufficient flow for specific fisheries. Specifically, we're looking at Mill Creek, Deer Creek, and Antelope Creek, and setting what we believe to be very minimal flows needed to protect spring run Chinook salmon.
And I'm assuming there will be a staff presentation, and I'm not sure who is in charge. You are. Okay, good. My goodness, we have excellent. The reason we have so many people at the front is that NOAA fishery staff are also joining us in this presentation. So we will take a few minutes to get everyone seated. Mariana, we saved that seat just for you.
Good afternoon. My name is Dan Schultz. I am the Acting Program Manager for the Water Quality Certification and Public Trust section in the Division of Water Rights. With me today from the Division of Water Rights are Les Grober and Dan Worth on my left. And on my right from the Office of Chief Counsel is David Rose and Mariana Awi. And we also have NIMP staff joining us, who we will introduce later. Today, I will be presenting an overview of the emergency regulation for curtailments of diversions due to insufficient flow for specific fisheries. Due to severe drought conditions, immediate action is needed to prevent the waste and unreasonable use of water in priority water bodies for threatened and endangered species in light of limited water availability. The State Water Board will need to curtail water diversions when natural flows decrease so that water is available for senior water right users, public trust needs for state and federally listed salmonids, and minimum health and safety needs. California is currently in the third year of a drought. Water year 2012 was categorized as below normal. Calendar year 2013 was the driest year in recorded history for many parts of California, and water year 2014 began on a similar dry trend. From February through April 2014, a series of precipitation events occurred that somewhat mitigated the dry hydrology and water supply conditions. However, dry conditions remain. Based on the April 1st forecast, the Sacramento and San Joaquin Valley water year types are still classified as critically dry. As of May 19th, the Northern Sierra snow water content is 5% of average to date. Rainfall and snow water content for the Northern Sierra is 60% of average to date for the water year. Based on these dry conditions, in May 2013, Governor Brown issued Executive Order B-2113, which directed the State Water Board and Department of Water Resources, among other things, to take immediate action to address dry conditions and water delivery limitations. In December 2013, the governor also formed a drought task force to review expected water allocations and the state's preparedness for a drought. On January 17, 2014, Governor Brown declared a drought state of emergency. The drought emergency proclamation recognized that changes to water supplies and diversions might be necessary to protect salmon and steelhead, to maintain water supplies and protect water quality. The proclamation ordered the State Water Board to put water right holders throughout the state on notice that they may be directed to cease or reduce water diversions based on water shortages. On January 17, 2014, the State Water Board issued a notice of surface water shortage and potential for curtailment of water right diversions. The notice advised that if dry weather conditions persist, the State Water Board will notify water right holders in critically dry watersheds of the requirement to limit or stop diversions of water under their water right based on their priority. Due to the dry hydrologic conditions, the State Water Board has begun issuing water diversion curtailment notices to water right holders within some critically dry watersheds. On March 1st, 2014, Governor Brown signed a drought relief package which provided funding for emergency supplies and to improve conservation, to reduce fire risk and increase firefighting capabilities, and it expanded the State Water Board's authority under Water Code Section 1058.5 and increased penalties for unauthorized diversions of water. On April 25, 2014, Governor Brown issued a proclamation of a continued state of emergency related to the drought. The proclamation finds that California's water supplies continue to be severely depleted, despite a limited amount of rainfall and snow since January, with very limited snowpack in the Sierra Nevada mountains, decreased water levels in California reservoirs, and reduced flows in the state's rivers. The proclamation orders that the provisions of the January 17, 2014 proclamation remain in full force and also adds several new provisions. One of these provisions is the State Water Board's direction to adopt and implement emergency regulations as appropriate to promote water recycling and curtail diversions when water is not available. Water Code Section 1058.5 grants the State Water Board the authority to adopt emergency regulations in certain drought years in order to prevent the waste, unreasonable use, unreasonable method of use, or unreasonable method of diversion of water, to promote water recycling or water conservation, to require curtailment of diversions when water is not available under the diverter's priority of right, or in furtherance of any of the foregoing, to require reporting of diversion or use or the preparation of monitoring reports. Emergency regulations adopted under Water Code Section 1058.5 remain in effect for up to 270 days. The finding of emergency is not subject to review by the Office of Administrative Law. Governor Brown's March 1, 2014 drought relief package expanded the State Water Board's authority under Water Code Section 1058.5 and increased penalties for unauthorized diversions. The water right priority system is based on the priority date of each water right and forms the basis for determining which users may divert and how much they may divert when there is insufficient water in the stream for all users. Older, more senior appropriative water rights have priority over more junior appropriative water rights. If there are additional questions regarding the types of water rights, we can return to this slide at the end of the presentation. The State Water Board has continuing authority under Water Code Sections 100 and 275 to introduce the requirements of the California Constitution, Article 10, Section 2, which directs the water resources of the state be put to beneficial use to the fullest extent, and that water not be wasted or unreasonably used. It further provides that rights to the use of water are limited to such water as is reasonably required for the beneficial use served, and does not extend to the waste, unreasonable use, unreasonable method of use, or unreasonable method of diversion of the water. Additionally, all water use in the state is subject to the public trust doctrine. All water users may only divert insofar as their use does not unreasonably harm fish and wildlife and other in-stream uses of water. Whether a use is reasonable under Article 10, Section 2 and the public trust depends heavily on the current situation and on competing demands for water. The reasonable use doctrine applies to diversion and use of both surface water and groundwater, and it applies irrespective of the type of water right held by the diverter or user. What constitutes an unreasonable use, method of diversion depends on the facts and circumstances of each case. Under the reasonable use doctrine, water right holders may be required to endure some inconvenience or to incur reasonable expenses. When the amount of water available in a surface water source is not sufficient to support the needs of existing water right holders and in-stream uses, junior appropriators must cease diversion in favor of higher priority rights. However, it is not always clear to a junior diverter whether there is sufficient natural flow in the system to support their diversion and senior water uses and in-stream needs downstream. As part of administrating water rights, the State Water Board may issue notices of curtailment to water right holders based on California's water right priority system. Diverting water when it is unavailable under your priority of right constitutes an unauthorized diversion and a trespass against the state. Violations could be subject to an administrative civil liability, or ACL, under the Water Code, or referred to the Attorney General. Administrative cease and desist orders and court injunctions may also be issued to require that diversions stop. An ACL for an unauthorized diversion may impose liability up to $1,000 a day plus $2,500 per acre-foot of water that is illegally diverted for violations during the current drought. Currently, for the State Water Board to take an enforcement action in absence of the regulation, curtailment would be based solely upon protecting senior water rights. Illegal diversion may be investigated and charged separately, and water right holders may request a full evidentiary hearing on issues that include availability of water under the water rights holder's priority. And the administrative decision is then subject to review in the Superior Court system. As such, enforcement in the absence of a regulation is cumbersome in that it is less likely to be effective in time to protect anadromous salmonids. In the current situation, time is of the essence. The curtailment in the absence of the regulation would also not address minimum flows needed for protection of the threatened anadromous salmonids. In a memorandum dated May 7, 2014, the National Marine Fisheries Service provided recommendations to the State Water Board for minimum in-stream flows in Mill, Deer, and Antelope creeks to address drought impacts on ESA-listed fish species. The memorandum also provided evidence to support the drought emergency minimum in-stream flows and pulse flows developed for this emergency regulation in Mill, Deer, and Antelope creeks. Mill, Deer, and Antelope creeks support multiple self-sustaining natural populations of anadromous salmonids, including listed Central Valley spring run Chinook salmon and California Central Valley steelhead. In these tributary systems, adult spring run Chinook migration typically occurs from March through July, with a peak in migration during April through June, and spring run Chinook juveniles are typically present from October through June, with a peak in out migration in January and February. Adult steelhead are typically present in these tributary systems during October through December and February through June. Juvenile steelhead can be present year-round. Mill, Deer, and Antelope creeks are recognized by the resource agencies for their high aquatic resource value. They support self-sustaining naturally produced populations of spring run Chinook and steelhead and are recognized as significant to the recovery of these threatened species. Unlike most tributary streams of the Sacramento and San Joaquin rivers that now have major water storage facilities that block miles of historical anadromous spawning habitat, the headwater stream habitat in Mill, Deer, and Antelope's Creek is relatively well preserved and is accessible for use by anadromous salmonids. A large amount of headwater stream habitat in these watersheds is located in the Lassen National Forest and provides a cold water refuge for salmonids even in drought years. Minimum flows are needed to provide passage for anadromous salmonids through the lower valley portion of these watersheds so they can access the cold water refuges in their spawning and rearing grounds. Due to limited diversions in the upper watersheds, minimum flows for spawning and rearing life stages have not been identified as an issue at this time. Adequate stream flow during migration periods will support the survival of adult spring run Chinook and steelhead by providing critical passage over shallow riffles and diversion structures and reducing water temperatures. It is anticipated that the irrigation season during this drought will begin earlier and last longer if drought conditions persist and overlap the critical migration periods for spring run Chinook and steelhead. This is a photo of one of the diversions along the proposed creeks. During low flow periods, the existing water rights on Mill, Deer, and Antelope Creek are sufficient to dewater the stream, and the gauge records show that they have been mostly or entirely dewatered by diversions in the summer period during dry years. In the next few slides, I will provide an overview of each section of the proposed emergency regulation. Proposed emergency regulation section 877 would establish drought emergency minimum flow levels in Deer, Mill, and Antelope creeks to allow for migratory passage of adult and juvenile spring run Chinook and steelhead. Staff recognizes that the drought emergency minimum flows proposed do not represent optimal passage conditions for spring run Chinook and steelhead under these drought conditions, and these minimum flows will result in stressful passage conditions for salmonids. Staff has identified the need for these drought emergency minimum flows during this drought period due to the lack of developed alternative water supplies to meet the water supply conditions that exist. Staff recommends that all water users take measures this year and in future years to develop alternative water supplies, since more protective and appropriate minimum flows for similar future drought conditions may be established in the future. The recommended minimum flows will be discussed in detail later on in this presentation. Proposed Section 878 would clarify that non-consumptive uses such as direct diversion for hydroelectric power generation are not required to curtail under orders issued under Section 877. Proposed Section 878.1 allows for limited diversions to meet minimum health and safety needs outside of the order of priority in furtherance of the constitutional prohibition against the unreasonable diversion or use of water. Based on the recommendation of the California Department of Public Health, the regulation uses 50 gallons per person per day as a benchmark for minimum health and safety diversions for municipal and domestic needs. Board regulations provide that between 55 and 75 gallons per person per day are reasonably necessary to supply the needs of fully plumbed homes. In this drought emergency, using a lower figure as a benchmark is reasonable. To prioritize State Water Board resources, these diversions of up to 4,500 gallons per day or 10 acre-feet per year of storage may self-certify that their diversions of up to 50 gallons per person per day meet applicable requirements. For larger municipal or domestic diversions, and for any diversion for health and safety needs of more than 50 gallons per person per day, Deputy Director approval is required. Minimum health and safety needs means the amount of water necessary for prevention of adverse impacts to human health and safety for which there is no reasonable alternative supply. This includes water supplies necessary for energy sources critical to basic grid reliability, fire preparedness and protection, critical air quality impacts, immediate health and safety threats, and other water needs not identified that are determined to be critical to public health and safety or the basic infrastructure of the state. Additionally, the regulation recognizes that strict application of the priority system can have harsh consequences for many water users that depend on diversions for water uses that are important on a personal, local, regional, and statewide level, and that many water users are working together to find mutually acceptable solutions to the water shortage. Similarly, the State Water Board understands that fishery agencies are working closely with water users across the state to implement voluntary measures to meet fishery needs in this extreme drought. To address this, Section 878.2 allows for water users to propose alternatives to following curtailment orders based on priority as issued under Section 877, and would allow the Deputy Director of Water Rights to approve such agreements, provided that diversions subject to the agreements are reasonable, do not injure or other lawful users of water, and provide the required flows at the same or greater level of protection to the fishery as the required flows, as affirmed by the National Marine Fisheries Service and the California Department of Fish and Wildlife. As just discussed, local cooperative solutions or voluntary programs may be proposed to the Deputy Director of Water Rights as an alternative means of reducing water use to preserve drought emergency minimum flows. Requests to implement voluntary agreements to coordinate diversions or share water in place of State Board issued curtailment orders under this article may be submitted to the Deputy Director of Water Rights at any time. The Deputy Director may approve a request if the Deputy Director determines the continued diversion is reasonable, that other uses of water will not be injured, and that the relevant minimum flows identified in this article will be met. If the National Marine Fisheries Service and the California Department of Fish and Wildlife conclude that the agreement provides watershed-wide protection for the fishery that is comparable to or greater than that provided by this regulation, the Deputy Director may also approve the request. The Deputy Director's approval may be subject to any conditions, including reporting requirements that the Deputy Director determines to be appropriate. If such a local solution is already in place at the time a curtailment order is issued, a diverter subject to a curtailment order must, within 5 days of issuance of the curtailment order, have submitted a petition to the Deputy Director and submit a certification under penalty of perjury that the diversion meets the conditions described in Section 879, Subdivision A4. Diversions covered by an agreement approved by the Deputy Director to coordinate diversions or share water pursuant to this section are subject to this article, and violations of such an approved agreement shall be subject to enforcement as a violation of this article. National Marine Fisheries Service and California Department of Fish and Wildlife currently have 2 signed agreements in Mill and Antelope Creeks. Staff will review the agreements to determine if they meet the requirements of Section 878.2 and thus obviate the need for curtailments in these creeks. National Marine Fisheries Service staff is here to speak to these agreements later on. Proposed Section 879 would establish a requirement that all water users who receive a curtailment order respond with information regarding their compliance with the order and an explanation of any diversions under other rights and any exceptions to curtailment. Such information will be critical to improving information concerning water depletions in this drought year. This section would further establish reporting requirements for health and safety exceptions to ensure that diversions out of priority remain minimal and are truly necessary. Proposed Section 879.2 would confirm that diversion or use of water in violation of proposed Article 24 is unauthorized and subject to enforcement, and would clarify that when a diverter is subject to multiple requirements, the most stringent applies. There are 3 local agencies and governments who will be fiscally impacted in Mill, Deer, and Antelope Creek watersheds. Based on information prepared by economists at the University of California, Davis, and using assumptions that show a higher projection of the potential range of costs, the State Water Board estimates that the cost to local agencies and governments will be approximately $1.01 million. This includes lost revenue in water sales, replacement water costs, and projected tax losses. Staff considers this cost estimate conservatively high because there is a lack of information on alternative water supplies. October impacts are based on 90% exceedance flows. Calculations for lost tax revenue from agriculture sales assumes a total loss of crops instead of reduced yield, and minimum flows for adult salmonids would be required for the entire time period identified in the regulation. In particular, this last element is not likely. To illustrate this point, let's go back and revisit the flows in more detail and when they are anticipated to be needed. This table illustrates the spring run Chinook salmon and steelhead life stage timing in Mill, Deer, and Antelope Creeks, and how the minimum flows overlap this timing. In this table, darker colors indicate the peak needs and timings for each life stage. Across the top of the table are the months, and down the last side is the life stage timing, and at the bottom is the flow requirement timing. Adult life stage timing and flows are in blue, and juveniles are in green. Adult spring run Chinook salmon and steelhead base flows of 50 cubic feet per second in Mill and Deer Creeks and 35 cubic feet per second in Antelope Creek have been identified as necessary to maintain the minimum flows needed for adult spring run Chinook salmon and steelhead during adult migratory periods. The juvenile base flows of 20 cubic feet per second is needed to maintain the minimum flows needed for juvenile outmigration periods. Pulse flow events are needed for adult spring run Chinook salmon to facilitate upstream migration of adults to their high-quality headwater habitat before environmental conditions such as water temperature become stressful and create a barrier to adult migration. Pulse flow events will also facilitate juvenile outmigration, which will flush juveniles out of the system and into the Sacramento River before environmental conditions become too stressful for juveniles. The white boxes above illustrate the months during which a particular species in life stage history is not expected to be migrating between the Sacramento River and Mill, Deer, or Antelope Creeks. The darker colored boxes illustrate the typical peaks in migration for either species, juvenile or adult life stage history, and the lighter colors represent less certainty of timing at the beginning and end of migration periods. As the graphic illustrates, adult spring run Chinook salmon upstream migration typically occurs during the months of February to July, with a peak of migration during April and May. Adult steelhead upstream migration typically peaks during October to November and January to March. Juvenile downstream migration for both species typically peaks during October to November and March to May. The spirit of the regulation is to only require minimum in-stream flows when spring runs Chinook salmon and steelhead are present and migrating through the lower watersheds. Staff anticipates, due to high water temperatures, the adult spring run migration period will likely be over at the beginning of June, and the juvenile outmigration period will be over around mid-June. If drought conditions persist in the fall, the migration period for adult steelhead will likely be delayed until around the beginning of November or the first large storm. If this is the case, the impacts of the regulation will be significantly less. The following 2 slides illustrate the curtailment impacts of the 2 scenarios we just discussed in Mill Creek. The curtailment plot shown here represents the impacts to water right holders if the adult spring run Chinook and steelhead minimum flows were required through the end of June and starting again at the beginning of October. The monthly drought emergency minimum flows are represented by the green line. The reported riparian demand is dark purple, reported pre-1914 demand is light purple, and the reported post-1914 demand is blue. The demands depicted in this graph are added on top of each other based on general priority. Two projected water supply scenarios are shown. The dashed blue line is the 50% exceedance flows, and the dashed red line is 90%. Water use may be curtailed during any period for which the demand line is above a dashed red or blue line, because these represent scenarios in which water demand is greater than the projected water supply. As you can see, based on the reported demand and projected water supply, the impact of the regulation under this more conservative scenario is in June and October. The impact would be a reduction of approximately 3,200 acre-feet of available water for diversion in June and 3,000 acre-feet in October. This curtailment plot represents one of the more likely anticipated scenarios discussed earlier. As mentioned, the regulation does not require the drought emergency minimum flows if spring run Chinook salmon or steelhead are not present during a part of their migration periods. This graph illustrates a curtailment scenario in which adult spring run Chinook migration is completed by June 1st, juvenile outmigration is complete by June 15th, and adult steelhead migration does not begin until November 1st, rather than October 1st. In comparison to the previous curtailment scenario, the effects to water right holders are less significant during the months of June and October. Under this scenario, the impact is a reduction of 1,000 acre-feet of available water for diversion in June and no impact in October. When we look at the different likely scenarios, it clearly demonstrates how conservatively high the estimated impacts that we discussed before are. This slide provides information on the emergency regulation resources. The webpage will be updated throughout the year. Interested parties can sign up on the Drought LIRIS list to receive emails when there are announcements related to this emergency regulation. For any specific curtailments that go out, we may have a specific LIRIS list for the affected watersheds. On the next two slides are the list of stakeholders who submitted comments.
One question on the, when you have an affected watershed and you're going to do a special outreach, how do you find the names of, I mean, you know, what special efforts do you go to make sure everyone on that watershed gets a notice?
For the situation of the emergency reg, we mailed out a letter to every water right holder in the 3 watersheds, and we would do a similar effort.
Okay, thank you.
I believe the regulation at one point asked people to sign up for the LIRIS list after they received the first letter of curtailments. On these slides are the stakeholder comments. We received a total of 9 comment letters. 5 were from local stakeholders on Mill, Deer, and Antelope Creek, and there are 4 that represent more general statewide concerns. So the next steps, upon board adoption, the regulation digest is submitted to the Office of Administrative Law for approval. The public may submit comments to OAL for 5 calendar days. OAL has up to 10 calendar days to review, and we would anticipate the regulation would go into effect June 2nd. During this time, staff will also review voluntary programs, track hydrology in Mill, Deer, and Antelope Creeks, and coordinate with the fish agencies. This concludes my presentation. Thank you, and are there any questions?
Why don't we hear from everyone first, unless Mr. O'Laughlin has a recommendation for us.
Well, no, we're Tim O'Laughlin, representing Deer Creek Irrigation District. So I'm going to be standing up periodically during this presentation and probably others and making certain comments and statements and then sitting down because we're going to make a record. So my first comment or statement is, since this is a quasi-adjudicatory process, my clients' water rights are at risk, and since you are doing a waste and unreasonable use determination on their water rights, according to due process, we would like to cross-examine this witness before we move to the other witnesses.
But
I
I
would
he-
like to hear from council. I don't believe this is a quasi-adjudicatory process.
I don't think it is either.
This is gonna be great.
Michael Lawford, Chief Counsel to the Board. I am not Jonathan Bishop, Chief Deputy. The process Mr. O'Loughlin is referring to is, of course, the Board's customary process where we have conducted adjudicative proceedings in order to establish and allocate flow requirements in an entity or person's water rights. However, it is not unprecedented for the Board to use waste and unreasonable use authority through a quasi-legislative proceeding. And we have made the determination here that it is appropriate, given the circumstances outlined in the resolution that's been prepared for the Board for today, to use a quasi-legislative process. As part of that quasi-legislative process, there is not an opportunity for cross-examination. Certainly, as Mr. O'Loughlin and others go through and they have questions, either for staff or for the Board that they would like the Board to have staff respond to, that would be helpful in identifying the issues. And certainly, I think for the Board members, in terms of making their determinations, they would like to hear a lot of those questions answered. This is an exigent circumstance where, in order to provide a timely and appropriate mechanism, the Board is, or Board staff is proposing that the Board proceed through this quasi-legislative process.